Now, Senator Weiner. SB 923, item number 5. Criminal investigation, eyewitness identification.
Thank you, Mr. Chairman, colleagues. Thank you for hearing SB 923 today. SB 923 will modernize and reform California's approach to eyewitness identification and photo lineups and ensure that we are convicting people who are guilty and not putting innocent people in jail due to faulty eyewitness identification. Almost nothing that we do as a state has the power to negatively impact an individual, to destroy families, communities, than wrongful convictions. It is an incredible injustice when an innocent person is sent to prison, not only for that person and their family and community, but because it means that a guilty person is out on the street. It does not help anyone to send innocent people to prison. And yet, unfortunately, that is happening today because California continues to have no statewide standards in place to ensure that law enforcement is using best practices for eyewitness identification. And as a result, we have an unacceptable risk of faulty identification. We know of 66 wrongful convictions. Some of them have been exonerated due to DNA, sometimes other reasons, but that is not acceptable. We need to use an evidence-based approach to eyewitness identifications, and unfortunately, we have that. And what we've included in SB 923, the standards that will now be statewide, are best practices. They've been endorsed by the National Academy of Sciences, by the U.S. Department of Justice, by the American Bar Association, by the International Association of Police Chiefs, and in 2008, they were recommended by our own California Commission on the Fair Administration of Justice. I will say that we have growing support for this bill, including recently, just a day or two ago, receiving a letter of support from the District Attorney of Santa Clara County. 19 states have adopted state requirements for eyewitness identification procedures, including Georgia, Nebraska, North Carolina, Ohio, Texas, and Virginia. So once again, and I've been here on this issue before, California is behind states that we sometimes perceive as less progressive than we are, and we are behind, and we need to catch up. SB 923 sets out minimum requirements for eyewitness identification procedures. First, it requires a blind or blinded administration of the photo lineup to prevent suggestiveness. In a blind lineup, the officer administering the procedure is unaware of the suspect's identity, so that the officer will not inadvertently suggest who the suspect is. If that is not practical, and we are sensitive that there are different departments have different staffing levels and different resource availability, so if the blind administration is not practical, a blinded technique can be used, such as the folder shuffle method in which a suspect and the filler photographs are placed in separate folders, shuffled, and handed to the eyewitness one at a time without the person administering the lineup knowing which person the witness is viewing at that moment in time. Number two, eyewitness instructions. Prior to the eyewitness identification or lack of identification, the eyewitness should be instructed that the perpetrator may or may not be in a lineup. In other words, do not assume that our suspect is in this lineup so that the person does not feel pressured to pick someone because the suspect absolutely must be there. Number three, proper use of fillers. So we want to make sure that the non-suspects look reasonably similar to the suspect You could imagine extreme situations where, for example, you have one African American in the lineup and everyone else is white, or someone who's 6'7" and everyone else is 5'2". We want to make sure that the fillers look enough like the suspect that the person is not going to be guided inappropriately to identify one person. Number 4, the bill will require that after the eyewitness makes an identification, if an identification happens, the eyewitness will be asked about his or her confidence level immediately. Are you very confident, somewhat confident, not very confident? That's actually very important than just I'm identifying this person. Let us know how confident you are. And finally, it requires that the identification process be recorded. And this is important. I know that some law enforcement agencies have suggested that this will be hard for them to administer. We've made amendments to the bill to make clear that it does not have to be fancy video recording. It could be on a very basic recording device. But this is, we're talking about someone's freedom. And I think it is totally reasonable to say we want to have this recorded so it can be scrutinized later if the case goes to trial. This is about making sure that the guilty go to jail and that the innocent don't. And that's why I ask for your support for SB 923. Joining me today to testify are 2 people, Alex Simpson, who's the Associate Director of the California Innocence Project, and Frankie Carrillo, an exoneree who was wrongfully convicted through incorrect eyewitness identification.
Thank you. Thank you to the committee, and thank you to Senator Winter for bringing this important bill. My name is Alex Simpson. I'm the Associate Director of the California Innocence Project, and our office is a proud sponsor of SB 923, along with the Northern California Innocence Project and the Loyola Project for the Innocent. What we're talking about are common sense, scientifically based standards to make sure that when we're doing an eyewitness identification procedure, that we get it right, both in terms of making sure that somebody who is not the actual perpetrator is correctly excluded from being a suspect, and also so that the procedure is recorded so that later on an individual who falsely accuses the officers of suggesting something to the witness, that the officers and the prosecution can say, that we did it right based on best practices. We have an interest in getting eyewitness identification procedures correct, and that's simply because when we get it wrong, the results can be devastating. What we've seen nationwide is that more than 70% of DNA-based exonerations across the country have as one of the factors an erroneous eyewitness identification as part of the conviction. Here in California, more than 92% of the DNA-based exonerations have as a factor eyewitness misidentification in the original conviction. And the reason is simply that eyewitness identification is incredibly powerful. There is nothing more powerful than a person getting up on the witness stand and pointing at the defendant and saying, that's the person who committed the crime. That's just not my words. That's Justice William Brennan of the United States Supreme Court who said that in 1981. And so the results are devastating when we get it wrong. We're here today with Frankie Carrillo, who, as a 16-year-old man, was erroneously misidentified as the shooter in a drive-by shooting. He spent more than 20 years in prison before he could get his conviction reversed. It was only after the original person who identified him said that he was mistaken, after the other 5 individuals said they couldn't see the actual perpetrator, that the court and the prosecution were able to reverse his conviction. That's how powerful it is that you have. And obviously when we're talking about eyewitness identification, sometimes that's the only thing in the case. It's not like CSI, where you might have a number of scientific-based forensic sciences that identify the individual. Sometimes it's only eyewitness identification. That's why we have to get it right. So I'm going to turn it over to Frankie. Thank you so much.
Good morning, Mr. Chair and members. And thank you for that. That was the trailer of my story, but let me give you the full impactful story of my life here. I was 16 years old in 1991, a high school student living in Southern California. My way of describing it was a typical life, but all that changed on January 24th of that same year of 1991, when 6 days prior there was a murder, as Mr. Simpson mentioned, drive-by shooting that resulted in the death of Donald Sarpy. He was a 41-year-old father, husband, pillar of the community, and so justice was quickly unleashed to find out who had done this. The investigation continued that afternoon, and they brought in a young boy who was 15 years old, who was shown a photographic lineup. The initial story was that he saw my image and he picked my picture, and those are the only grounds at the time to arrest me. And so 6 days later, I was arrested, tried as an adult because I was only 16 years old. Soon I was facing a jury trial where I was convicted, sentenced to 30 years to life plus life, and the story was supposed to end there. That was supposed to be the end of Frankie Carrillo's existence in the free world. Because of dogged pursuit of justice and the belief that this was a mistake, it could be corrected, I didn't give up on myself, nor did my family or friends. And 15 years after that conviction, I obtained representation by the Northern California Innocence Project, Morrison & Forster, which is an international law firm, and a number of people who just came to my rescue. And during this reinvestigation, it was discovered that this young boy, who I mentioned earlier, who was only 15 years old, selected my photograph, and that was grounds to arrest me. It didn't happen that the way it was written down. And so the boy had been awake. The crime happened at 7 p.m. It was now 2 in the morning, and he's shown this photographic lineup. And the story that this now man testified to was that he picked a photograph, and the deputy said, "No, that guy's in jail. Try again." And so I'm sure he feels not too confident in his abilities as a witness. He picks another photograph, and this time it was of a dead person. And so the cop just says, like, this guy we think is trying to earn his keep in the street organization. This is who we think did it. So the boy at that point, I'm sure if I was in that situation, would agree as well. The boy then told the other witnesses that if they ever show you any photographs, to please pick picture number 1, that he's confident that's the person who did it. And so 7 months after the crime, the other witnesses were shown photographs, and they too picked my image, picture number 1. It's a very multi-layered story, and I'm happy to be home. I've been home now for 7 years, and I try to find the gems in what happened, and this is one of them now. This moment here, through this committee and through this process of finally implementing some policies that will make sure that this would not happen again. And so my pain and what I went through, if it means anything, I hope that it means something to legislators here, that this can be resolved and that it'll never happen again.
Thank you.
Thank you.
Any other witnesses in support? Name and organization.
Kathy Scher on behalf of the ACLU of California. We are a proud co-sponsor of the bill.
Margot George, California Public Defenders Association, in support.
Angelique York with National Association of Social Workers in strong support.
Thank you.
Derek Morgan with the Ella Baker Center for Human Rights, here in support.
Tunisia Owens with the Ella Baker Center in strong support.
Thank you.
Larry Doyle on behalf of the Conference of California Bar Associations in support.
Tamar Tokat with the Los Angeles County District Attorney's Office. We have a supportive amended position, and we've been working diligently with the Senator's office, and they've been very generous, and we hope to be able to reach a support position. Thank you.
Thank you.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice in support.
Thank you. Are there any witnesses in opposition? I think they need one more seat.
Thank you, Mr. Chair and members, Matthew Cyberling on behalf of the Association for Los Angeles Deputy Sheriffs, the Los Angeles Police Protective League, and the Association of Deputy District Attorneys, representing Deputy District Attorneys in Los Angeles. I'll say this, we agree with a lot of what's in the bill. A lot of it is common sense. We want to put protections into place to make sure that we get the right people that we're looking for when these crimes are committed, and that we bring suspects to justice. The one thing we do caution about, and we'd appreciate the opportunity to keep working with the author and the sponsors on, is just to make sure that we don't put into place too many roadblocks, too many hurdles, and too many chilling effects to either make people unwilling to or too afraid to testify or make identifications of potentially their neighbors, their community members that they find in these six-pack lineups. We feel that the mandate to videotape is often an opportunity for people to simply walk away from an officer because they're afraid to appear on videotape, making these statements of these identifications. Just for starters. So, as the bill moves along, we'd hope to continue to work with you. We do have some strong concerns and would hope that we could find some middle ground. Thank you.
Thank you.
Chair and members, Jonathan Feldman with the California Police Chiefs Association. Kind of in the same boat with my colleague here. Agree with the intent of the bill, the purpose of the bill. There's some practical concerns that we have with some of the provisions, video recording, making sure that lineups in the field are accounted for. But we appreciate the most recent set of amendments that the Senator took. They really helped clarify a few things for us, and we look forward to working with him to resolve our outstanding issues as the bill moves forward.
Thank you.
John Lovell on behalf of the California Association of Code Enforcement Officers, College and University Police Chiefs, California Narcotic Officers Association, and the LA County Professional Peace Officers Association. I'd like to echo the statements of the prior witnesses. We believe, as does the Senator, that it's important that eyewitness identification is done right. Because you have two tragedies. If you have a wrongful identification, you have an innocent person incarcerated, but the real bad actor has gone free and is still around to commit subsequent crimes, and there's some chilling statistics about that. That said, we are very concerned about some provisions of this bill that have the unintended consequence of chilling witnesses from coming forward. Speaking specifically of the audio and video recording. Let's face it, people don't volunteer to be witnesses. They have to be persuaded to come forward. There's a real on-the-ground fear factor, particularly when the witness is identifying someone in his or her immediate neighborhood. And we think that that issue has to be taken very seriously, because the other thing we don't want is a bill that inadvertently discourages witnesses from coming forward, which in its own way is as damaging as a false identification. And we look forward to continuing to work with the author's office in addressing that serious unintended consequence. Thank you.
Thank you. Any other witnesses in opposition? Any questions from committee members? Ms. Carrillo.
Thank you. Not so much a question as to just a acknowledgement to Frankie. Frankie, thank you for being here, for sharing your story, for having the courage to enter the people's house, and to let us all understand that we've made mistakes as legislators in the past, and that we have an opportunity to create a new type of California. And I want to thank the Senator for bringing this to our attention in terms of what we can do to ensure that justice is served. And just for clarification, I know the witness personally. We've gotten to know each other the last 2 years or so. Mm-hmm. He's a pillar in our community and someone who advocates for justice on all levels. And so I just want to say thank you again for being here, for being a part of this, and for sharing your story.
Thank you.
Thank you. Senator, you may. Mr. Kiley.
Good morning. I'll echo my colleagues' comments. Thank you very much for being here to share your story. I guess my issue with this is, we already have a pretty powerful incentive to avoid shoddy eyewitness identification practices, and that's the threat of exclusion. if a court deems an identification to be unreliable. So I guess two questions. So why are the existing touchstones of reliability that have been developed in the case law insufficient as a deterrent? And then I guess secondly, how would these policies that are put in place by this bill interact with kind of the judicial standards for the reliability of eyewitness identification?
Sure. I mean, judicial standards are a baseline. We're, I think, going above that and saying that these are the specific things that we believe in California are necessary to ensure accurate eyewitness identifications and to make sure that innocent people are not being sent to prison. And yes, if an eyewitness identification is so poorly conducted to the point where it violates the Constitution, it can be excluded. But first of all, it's very hard to get there, especially when you're not recording anything and it becomes a he said, she said. But again, we're taking that constitutional foundation and saying we're going to flesh it out even more to have more specific standards in California. Sometimes the constitutional standards it's a minimum. It doesn't mean that it's enough. I don't know if you want to.
Yeah, just to clarify, when we're talking about constitutional standards for exclusion of identifications, the standard is that the eyewitness identification procedure is so flawed that there is a substantial likelihood of irreparable misidentification. So when we're talking about the standards that we're talking about in this bill, the issue for the United States Supreme Court or the California Supreme Court is that there has to be no doubt that the court has that the identification is accurate. And so when we're talking about a witness who comes forward months or years later and says in court, I am now 100% confident after an officer has told me that I got it right, or after I've seen a six-pack photo array of the suspect 2 or 3 or 4 times, and after I see the defendant in the defendant's chair, that I am now confident that this person is the person that I saw. The court will say, okay, well, I believe that this person is being truthful and credible and accurate when he identifies the individual. The problem is that the original identification procedure may be flawed. And so when we have these standards in place, we remove the likelihood that it is an inaccurate identification and that the witness isn't later more confident in their identification. And unfortunately that the court will not exclude that. So that's really what we're talking about. It's just making sure that at the very first part of it that we remove the inaccuracy, the persuasiveness, that sort of thing.
But correct me if I'm wrong, but I think the court can look at the procedure that was used in assessing whether the identification is admissible. So if you have a lineup where everyone's a foot taller than the suspect, then the court's probably going to throw that out, isn't it?
Unfortunately, what we're talking about is, when we're talking about exclusion, courts are very, very reluctant to exclude an identification. Oftentimes, the identification is the only evidence against the individual. So they don't want to, courts generally will not want to toss out a case. Obviously, if you have an identification is the sole reason for the prosecution. If the prosecution is based on that, then a court will be reluctant to exclude. And so what we're really just trying to make sure is at the very beginning that everybody understands, based on common sense, scientifically based practices, that the identification procedure is done accurately to ensure that the witness is as accurate and as confident in their identification as possible.
Okay. Thank you. Any other questions from committee members? You may close.
Thank you very much, Mr. Chairman, and rest assured that we will continue to work with our law enforcement agencies as we have been from the beginning. We absolutely we want to have a strong bill that reforms eyewitness identification in California, and of course we want it to be administrable, if that's a word, by our law enforcement agencies. So we'll continue to have those discussions. But I also just don't ever want to lose sight of the fact of what we're talking about here, that these are real people, real lives that are as strong as folks can be in coming back and making great lives for themselves. This changes people forever. This is, 10, 20 years of your life. I have to say, having presented this bill a few times now and met, various exonerees, it's really hard just to sit there and listen to what they have to say. It is hard to even listen to it because it's hard to even imagine what that would be like if you were in that situation, or if a loved one or a friend, someone in your community. It is just unimaginable. And we know what will fix it. We have the tools to dramatically reduce the risk of that ever happening again. And I think we should take those tools and use them. And I ask for your aye vote.
Thank you. We need a motion and a second. It's been moved and second, and I think you've done a magnificent job at least trying to thread the needle in concerns. And the only suggestion I will make, because my recommendation is an aye, is to the concerns from law enforcement that witnesses are protected, and that if you go at it from how do we protect the witnesses, not how do you get witnesses to come forward, because that may lead to you being a little more, crossing the line sometimes. But if you're really trying to protect the witness and making sure if you record them, that could have some repercussions that could be really catastrophic. And if you go with that, I think you might be able to thread the needle to work with law enforcement to come up with the safeguards so that we can get people to not only testify and testify accurately, that they will show up in 6 months and that they will be around in a year from now if the trial takes that long. And so I think it's very important to work with law enforcement. And I think the Senator Wiener will work with you to come up with those safeguards. And so I'm recommending an aye vote.
Thank you.
Call the roll.
SB 923, the motion is due pass to the Appropriations Committee. Jones Sawyer.
Aye.
Jones Sawyer, aye. Lackey. Aye. Lackey, aye. Carrillo. Carrillo, aye. McCarty. McCarty, aye. Kiley. Kiley, no. Quirk. Weber.
That bill passes. Congratulations.
Thank you very much. Thank you, Mr. Chairman.
Senator